Good evening. How's everybody doing? Great to be learning with you on a Tuesday. Let's light up. Great to be learning with you on a Tuesday. Let's light up the darkness. We've got audio, right? We're going to have to block my face. Okay, there we go. So much going on. I've been doing lots of radio appearances and podcast appearances, and I always have to reconfigure the setup over here. But so great to be learning with you today. Who's in the house? Yehuda in South Carolina and Indiana, Shandor in the Bronx, Guy in Ohio, Melissa in Great Neck, Bill in mid-Missouri, Belle in Texas, Bella in Florida, Lucy in Minnesota, Karen in Northern California, Gail in Kansas City, Paul in the Great Northwest, Yosef in Sierra Nevada. YouTube hiding you from me, but I reload. And then I can see Aoife in Florida, Allen, New York City, Frank in San Pedro, Hyman, Florida, Norm in 29 Palms. Welcome, everybody. Today's episode of AT Daily is sponsored by Gary and Claudia Polachek. In memory of Gary's grandfather, Chaim Aron Ben Nissen. The merit our learning should accrue to him and give him an even higher place in the world to come. And Gary, may you and Claudia and all your loved ones be showered in blessings. Thank you for enabling us to share more Torah with more people around the world. If you'd like to sponsor an episode of AT Daily, donate.accidentaltalmudist.org. Okay, we are in tractate Makkos, the 25th volume of the Talmud, and it's time to start playing catch-up. To get back on the Daf Yomi schedule. It's my intent to basically keep doing 2 a day until we catch up. Sometimes when the 2, still come out a little bit long, I will summarize certain sections so that we can keep it, to about an hour or less. Okay, so we're picking this up near the bottom of page 3A. We got, about halfway down page 3A. And we completed our discussion of Mishna number 1 here in chapter 1 of tractate Makkos. We're going to start with Mishna number 2, but I will answer a question that Karen asked, right? Was it Karen? Who was that asked that question? That Karen asked on, it must have been Friday, excuse me, or was it Saturday night? Maybe it was Saturday night, whatever. The question was, it was Saturday night. The question was, why is it that all the tractates of the Talmud begin on page 2? And I didn't have the answer ready to mind, although I said it was something, basically it was the way that they were published. Now the Talmud, was written down long before there were published books like this, right? This is what we think of as a book. This is actually called a codex because if you think about a rolled Torah scroll, that's also a book, right? And we actually call it a Sefer Torah, the book of the Torah. But in the ancient world, books were made in rolls, right, on dowels. And eventually, people were able to manufacture books like this. Initially, they were in this form, but handwritten. And then, of course, the printing press changed everything. And when there was an early printed edition of the Talmud with pages, and that required numbering. So in the very early days of doing that, it was pretty normal to put all the title and, edition information, where it was printed, who printed, etc., on the first page, and to start on page 2. Now, we could have done away with that as we got more into the modern era, but we preserved that all tractates start on page 2, and a few explanations are given for that. The one I really like is that it reminds us that our learning never really begins and never really ends, right? We're always in a cycle of learning, even if we haven't done Daf Yomi before. When we start, of course, we come right in the middle, right? Within the text, we start on page 2. And when we finish, we always go right into the next tractate, because learning never ends. The obligation to learn never ends. We can never feel, who could even contemplate to think that they've mastered it all. You have modern, sages that are just beyond comprehension how sagely they are or were. People like Moshe Feinstein, who completed Daf Yomi, well over 100 times. I mean, he made a siyum on the entire Talmud, I think maybe 150 times, something like that. Incredible. And who was it? This is Rabbi Kanevsky in Israel, who reads all of the learning that we basically call the canon of Jewish learning, right? He does the entire Torah, the entire Talmud, the entire Mishna, the entire Shulchan Aruch, the entire Rambam, Mishnah Torah. I mean, like, every year, so there's some people that just never stop learning. They know so much more and have memorized so much more than we could ever imagine. And of course, they keep learning and learning and learning. We should be inspired by them. So that's basically the way I like to think of it. Okay, Mishnah number 2 here in Tractate Makkos, the 25th volume of the Talmud, chapter 1. Mishnah 2. In the case of witnesses who said, we testify with regard to a man named so-and-so, that he divorced his wife and did not give her payment of her marriage contract. And then they were rendered conspiring witnesses. So these people came and they lied, right? And they said that this man divorced his wife and that he didn't pay the marriage contract, which became due after he divorced her. But it was a lie. He never divorced her, and that's why he never paid her. So now the question is, what is the punishment going to be? Because as we've seen conspiring witnesses, the Torah says you shall do to them as they conspired to do to the one that they were going to harm, right? Maybe these guys aren't married. I mean, are we going to say that they are now divorced from, or maybe they are, but are we going to say that because they lied and said that this guy divorced his wife and he owes and didn't pay the money, that now we're going to make them divorce their wives? No, that's not what we're going to do. So they conspired and they claimed that some man divorced his wife and didn't pay the marriage contract, and they were rendered conspiring witnesses. So the question arises with regard to the manner in which the sum of their payment is calculated. We're not going to get involved with their marriage. But, right, this man who didn't divorce his wife, therefore, doesn't owe her the ketubah payment, the payment of the marriage contract. These liars would have made him obligated to pay that much money. So we should make them, the conspiring witnesses, pay the amount of money that they would have obligated the person that they testified falsely about. But that's not so simple. Right? So the question arises with regard to the manner in which the sum of their payment is calculated. It is not possible to render the witnesses liable to pay the entire sum of the marriage contract. Why? Because they can claim, but isn't it so that either today or tomorrow, i.e. at some point in the future, he might divorce his wife, or he might die before her, and ultimately he would be liable to give her the payment of her marriage contract. And that being the case, the witnesses did not conspire to render him liable to pay a sum that he would otherwise not be liable to pay, right? It's very likely that someday he will be, or his estate will be liable to make this payment. On the other hand, if she predeceases him, if the wife dies before the husband, then he inherits her property, and he never did become liable to pay her the marriage contract. So, how do we calculate the present value of what they conspired to do, which was to render him liable to pay the marriage contract now? So the sum of their payment is calculated like this. The court assesses how much money another person would be willing to give in order to purchase the rights to this woman's marriage contract, cognizant of the uncertainty that if she was widowed or divorced, the purchaser will receive payment of the marriage contract. But if she dies, her husband will inherit from her, and the one who purchased her marriage contract will receive nothing. Right? So imagine there was a wealthy couple, and when they got married, he agreed that, if he dies before her or divorces her, he will owe her $1 million. And let's say this couple is now in their 60s, right? So if she dies before him, this never gets paid. If he dies before her or he divorces her, he has to pay $1 million. That's the situation. How much would it be worth to you to purchase the rights to that contract, right? Let's say she's very healthy, he's kind of sick, So you can think, well, odds are he's going to end up paying. And odds are he's going to end up paying within, 20 years. Most likely within 20 years he'll pay. Within 30 years he'll pay. But it's a long time, So maybe what's that worth to you? To have the rights to receive $1 million. You might never get it, but you probably will. You might get it sooner, but you probably not get it for, a decade or two. So what's that worth to you? Maybe it's worth $10,000. Maybe it's worth $50,000. Some actuary, could tell you exactly what the probabilities are and what it should be worth to you. That is what these conspiring witnesses would be liable to pay. That's the Mishna, now the Gemara. The Mishna establishes that the payment of the conspiring witnesses is calculated based on the sum that one would be willing to pay for rights to payment of the marriage contract, taking into consideration the uncertainty whether he will ultimately receive that payment. The Gemara asks, how does the court assess that sum? And Rav Chisda says one calculates the sum in terms of the husband. How much would one be willing to pay for the husband's rights to the marriage contract based on the likelihood that his wife will die first and he will inherit from her and that he won't have to pay? We don't follow that. Rav Nassan Bar Oshaya says one calculates the sum in terms of the wife. How much would one be willing to pay for the wife's rights to the marriage contract based on the likelihood that the husband will die first or divorce her? That's basically what we do. Rav Papa says one calculates the sum in terms of the wife, as Rav Nassan Bar Oshaya said, and the assessment is done in terms of the sum of her marriage contract. We do not include in the calculation any usufruct property that the wife brought with her into the marriage, the profits of which belong to the husband, despite the fact that as a result of the testimony of the conspiring witnesses, the husband would lose the rights to those profits. One calculates the sum only in terms of her marriage contract, and that is the law. That's it. Now Mishnah number 3 of chapter 1. In the case of witnesses who say, witnesses who said, again, there's going to be conspiring witnesses, we testify with regard to a man named so-and-so that he owes another person 1,000 dinars that he borrowed on the condition that he is to give the money back to him from now until 30 days have passed. Meaning, to pay it back, it's a large sum of money. 1,000 dinars was like 8 months average salary. And this guy and the conspiring witnesses said he borrowed it and he agreed to pay it back within 30 days. And the borrower says that he borrowed that sum. Yes, he borrowed 1,000 dinars, but it was on the condition that he would pay it back within 10 years, not 30 days. And then we learned that the conspiring witnesses were liars. So we're not going to make them pay 1,000 dinars, right? I mean, the guy already admits that he owes 1,000 dinars. They weren't rendering him liable to pay something that he wouldn't otherwise have to pay. But the conspiring witnesses were making him pay it in 30 days rather than 10 years. So what is that time value of the money worth? What is it worth to a person who owes 1,000 dinars to have 10 years to pay it back versus 30 days? So rather, the court estimates how much money a person would be willing to give so that he would keep a loan of 1,000 dinars in his possession rather than have to pay it back. And one calculates the difference between that sum in a situation where he would be required to give the money back within 30 days or to give it back versus giving it back within 10 years, right? What is that time value of money worth? You can see right away that there's a tremendous sophistication to these laws, right? Like, did we think that in the ancient world, they had these kinds of, financial mathematics and actuarial tables? Yes, they did. They very much did. That's the Mishna. Now the Gemara. Rav Yehuda says that Shmuel says, in the case of one who lends money to another for a period of 10 years, right, when the temple is standing in Jerusalem, right, and the land of Israel is being governed by Torah law, well, we know that every 7 years we have a Shemitah year, right, the sabbatical year, and one of the actions that the Torah mandates happens in a sabbatical year is that debts between Jews are canceled. And that happens every 7 years. So if that happens every 7 years, then a loan for 10 years that was going to be paid back 10 years later, well, 7 years would have elapsed sometime during that loan period, and presumably the loan would have been canceled. So what are we even talking about here? Maybe we should say, well, if he's only going to have to pay it back in 10 years, and the Shemitah cycle was going to renew, and then he wouldn't have to pay it back at all, but now he's being told to pay, because of the conspiring testimony of the witnesses, pay it back in 30 days. So maybe we should make these witnesses pay the full 1,000 dinars. Why is that not the case? Because as we're going to see, the Shemitah cycle does not abrogate, does not cancel certain kinds of loans, even though it does cancel others. Let's see. Rav Yehuda says that Shmuel says in the case of one who lends money to another for a period of 10 years, the sabbatical year abrogates and absolves the borrower of the obligation to repay it. Now we're in 3b. And even though now, during the sabbatical year, we do not yet read concerning his loan the prohibition, he shall not exact it of his neighbor and his brother because the Lord's release has been proclaimed, right, meaning the debt is canceled. Even though we don't say that now, as we don't say that until the sabbatical year arrives, nevertheless, ultimately, when the time for repayment comes, he will come to a situation where the prohibition, he shall not exact it, does apply, right? Because over a 10-year period, the sabbatical year will have arrived. So why are we talking about this? Rav Kahana objects to that and says, no, not quite. Rather, the court estimates how much money a person would be willing to give so that he would keep a loan of 1,000 dinars in his possession. And one calculates the difference between that and that sum in a situation where he would have to be required to give the money back in 30 days have passed. And that same sum in a situation where he would be required to give the money from now until 10 years have passed. And if you say that the sabbatical year abrogates a 10-year loan, the conspiring witnesses need to pay the borrower the entire sum of the loan as well, as their testimony sought to render the borrower liable to pay a debt that by right should be entirely forgiven, right? What I said before. So if the sabbatical year cancels it, well, then we should make the conspiring witnesses pay all of it because, as from the borrower's point of view, he would have the loan canceled. But Rava says, what are we dealing with here in our Mishnah? We are dealing with debts that are not abrogated with the passing of the sabbatical year. For example, in the case of one who lends money on the basis of collateral, if there's collateral for the loan in the possession of the lender, the debt does not get canceled when the sabbatical year arrives. Or in the case of one who transfers his promissory notes to the court for collection, because again, here it's not you saying to your brother, pay me back, and in defiance of the sabbatical year, because a court is not asking for payment from my brother. A court, if you transfer your promissory note to a court, the court can collect it, and that was by rabbinic decree, because if people who needed to borrow money were not able to get loans because of the cancellation of the sabbatical year. and therefore they created this mechanism where the loan would survive the abrogation, the normal abrogation of the sabbatical year. This was a way to get around that by transferring the promissory note to the court for collection. As we learned in the Mishna, in the cases of one who lends money on the basis of collateral and one who transfers his promissory notes to the court for collection, the sabbatical year does not abrogate those loans. So in those cases, the debt would not have been forgiven during the sabbatical year. Therefore, the conspiring witnesses are not liable to pay the entire sum, but rather they would have to pay the difference in value between a loan that has to be paid back in 30 days versus being paid back in 10 years. And that could be substantial, because if you can hold on to the 1,000 dinars that you borrowed for 10 years rather than 30 days, well, you could do a lot with that money over the course of 10 years. And there are those who state another version of this discussion. And basically, it's the same argument, except that Rav Yehuda says that Shmuel says that that one who lends to another for a period of 10 years, the sabbatical does not abrogate, right? And then Rav Kahana, instead of objecting, offers the same kind of statement before that supports, and then Rava gives the same clarification. So this is one place where we can summarize a little so that we can do a double today. And Rav Yehuda says, now, we just said a kind of argument, and we said it twice, that Rav Yehuda says in the name of Shmuel, and then Rav Kahana asks a question or lodges an objection, and then Rava settles the dispute, and then we understand how the halacha works in that situation. So now the Gemara is going to give 3 situations that follow this same pattern. Rav Yehuda says that Shmuel says, with regard to abrogation of debts, in the case of one who says to another, the stipulation, I'm lending you money on the condition that the sabbatical year will not abrogate my debt. Even if the borrower agrees to the stipulation, the sabbatical year abrogates the debt. And the Gemara suggests, well, let us say that Shmuel holds that the lender who proposed that stipulation is one who stipulates counter to that which is written in the Torah. And in the case of anyone who stipulates counter to that which is written in the Torah, the stipulation is voided. Right? So instead of saying we're going to transfer the promissory notes to the court or we're going to lend on collateral, what if the borrower and lender just agree that, okay, when the sabbatical year comes up, we will not abrogate the debt? Can they do that? Doesn't that violate a specifically written law in the Torah? So the Gemara asks, but wasn't it stated that there is a dispute between Rav and Shmuel concerning this matter? In the case of one who says to another, the stipulation, I am selling you this item on condition that you have no claim of exploitation against me, right? Because if you charge more than 16%, 1/6 of the value, right? If the deal is off by more than 1/6 of the market value, one can later claim, oh, you ripped me off, right? You either got it for too little or I paid too much, and therefore we can unwind the sale. Well, and that's by Torah law because you can't exploit your fellow. But what if they say, okay, well, I stipulate that I don't care. I understand I'm overpaying. I just want the object. Can they do that? I am selling you this item on the condition that you have no claim of exploitation against me if I charge you more than the item is worth. And Rav says the buyer has a claim of exploitation against him, even though he explicitly waived his right. Why? As one cannot stipulate to waive the law of exploitation. But Shmuel says he has no claim of exploitation against him. So apparently, according to Shmuel, one may stipulate to waive a Torah law in monetary matters, as it is tantamount to waiving his rights to money that is due to him, and it is not in effect counter to that which is written in the Torah. The Torah gives you a protection. If you waive the protection that the Torah affords you, then you're just giving up your right to a monetary claim. It's not like you're setting aside Torah law. You're just saying, I don't need the benefit of that Torah protection. So the Gemara answers, wasn't it stated with regard to that law that Rav Anan said, it was explained to me personally by Shmuel himself, that the matter depends on the formulation of the stipulation. If the seller stipulates on the condition that you have no claim of exploitation against me, then the buyer has no claim of exploitation against him. As though he is waiving his right to money that is due to him, and you can always do that. But if the seller stipulates, on the condition that there is no prohibition of exploitation in this transaction, then there would be a prohibition of exploitation in the transaction. In other words, if you say something that is contrary to Torah law, like, yeah, well, in this transaction, there is no prohibition of exploitation. Well, no, there is a prohibition of exploitation. What you can say is, I waive my rights to be protected by the prohibition on exploitation. But you can't say that there is no prohibition on exploitation, because that would be denying a fundamental Torah precept. And Ravanan continues, so here too, if the lender stipulated to the borrower, I am lending you money on the condition that you will not abrogate the debt during the sabbatical year, the sabbatical year does not abrogate his debt, as the borrower is merely waiving money that is due to him. But if he worded it like this, on the condition that the sabbatical year will not abrogate my debt, then the sabbatical year does abrogate the debt, as that kind of wording creates a stipulation that would nullify the laws of the sabbatical year, and we don't allow it. New subject, apropos the loan that was discussed in the Mishna, the Gemara cites a sage who taught, one who lends money to another for an unspecified period is not permitted to demand repayment from him less than 30 days after the loan took place. And the Gemara comments, Rabbi Bar Chana, who was seated before Rab, thought to say, this statement applies only with regard to a loan with a promissory note, as a person does not typically exert himself to write a promissory note for a loan whose duration is less than 30 days. But with regard to a loan by oral agreement, no, it may be for less than 30 days. And Rab said to him, this is what my uncle Rabbi Chia said, the law applies to both one who lends with a promissory note and one who lends by oral agreement. If one fails to establish a time of repayment for the loan, the lender may not demand repayment until 30 days have passed. That's the standard period where a period is not specified. The Gemara notes, this is also taught in a Baraisa, one who lends money to another for an unspecified period is not permitted to demand payment for him less than 30 days after the loan took place, and that is the case both with regard to one who lends with a promissory and one who lends by oral agreement. And the Gemara relates, Shmuel said to Rav Matana, you shall not sit on your feet until you have explained this law, meaning tell me it immediately. From where is this matter that the sages stated derived that one who lends money to another for an unspecified period is not permitted to demand payment for him less than 30 days, both with a promissory note and by oral agreement? Where do you get this law in the Torah? So Rav Matana said to him that it is derived from a verse, as it is written, the seventh year, the sabbatical year, approaches. So the question arises from the fact that it is stated the seventh year approaches. Don't I know that it is the sabbatical year? So rather, why must the verse state the sabbatical year? Seems redundant. What are we to learn from this? This is to tell you that there is another period that is like the sabbatical year. And which period is it? It is the period in the case of one who lends money to another for an unspecified period, who is not permitted to demand repayment from him in less than 30 days after the loan took place. During that period, as during the sabbatical year, one may not exact payment for his loan. And in what sense can that period be characterized as a year? We're talking about 30 days. How can you say that 30 days is like a year? It is as the master said. 30 days in a year are considered a year. Have we entered a new year with respect to a financial matter? If we're only a few days into that year, we're not in that new year yet. But once 30 days have passed, it's like a year has passed for the purpose of certain kinds of timing and financial matters. We don't have to get into that because really this chapter is about what kind of penalty are we going to impose on conspiring witnesses, where it's complicated to say what damage would they have caused if their testimony was believed. But now that we had a couple of matters where we said Rav Yehuda says in the name of Rav, and Rav Kahana lodges an objection, and then Rava resolves the dispute, the Gemara is going to make a total digression on three other kinds of laws that have nothing to do with conspiring witnesses and don't even have to do with damages or monetary matters or measuring when debts have to be repaid at all. It's just a total... Excuse me. Excuse me. This is just a digression. I'm talking too fast. I'm sorry, Nina, if you can hear me. Please, sweetie. I should always bring my glass of water here. But anyway, so it's 3 digressions on matters unrelated to the material of this chapter. So I'm going to summarize them for you with the law, just where the law came out on these 3 matters, so that we can accomplish a double daf today. Number 1 has to do with one who opens the neck opening of a shirt on Shabbos and how that compares to somebody who uncorks a bottle of wine. Can you uncork a bottle of wine on Shabbos? Absolutely. We do it all the time. Why wouldn't you be able to do that? Because before you uncork it, it's just a sealed bottle of wine. After you take the cork out of a bottle of wine, okay, so you can pour, the wine into... Oh, thank you so much, honey. I appreciate that. Baruch atah Adonai Eloheinu melech haolam shach v'derach. After you pour the wine into the glasses, you've now got an empty wine bottle. Could you pour water into that and bring the wine bottle full of water? Or wine, from like an open cask that you have, just put more wine in it and bring it to the table in that wine bottle? Yes, you could. So in a sense, didn't you create a vessel for carrying liquids that you didn't have available to you before Shabbos? Answer, no, because the wine bottle was always a vessel that contained the liquid, and that cork was only in it for the purpose of being pulled out. However, the way that they used to send you a shirt, like a cloak that was kind of a pullover, is that and the way that they launder it too, is that they would sew close with stitches the neck opening of the garment. And those stitches you could not remove on Shabbos, because that would be like finishing the garment. One who opens a neck opening in a garment on Shabbos is liable to bring a sin offering for violating the primary category of labor known as striking a blow with a hammer, meaning finishing the item, or for violating the primary category of tearing if his intent was to then sew the garment. And the Rima writes that this law applies even to a garment that had an opening that was sewn shut by a craftsman for repairs or for laundering. And we don't compare that to pulling a cork out of a bottle. The second matter, where Rav Yehuda says that Rav says, Rav Kahana objects, and then Rava clarifies, this has to do with a mikveh. A mikveh has a minimum volume, right? A ritual bath that you will, if you have to immerse for the sake of purification because you came into contact with tuma. For example, a woman, after she counts her days, her clean days after a menstrual cycle, immerses in a mikveh. Or somebody, when the temple was standing, who came into contact with a dead body and then was, sprinkled with water. The waters of sprinkling on the 3rd and 7th day. Then they have to immerse in the mikveh, right? Many uses of a mikveh. So a mikveh has a minimum volume of 40 sa of water. It's like about the size of a bathtub. Enough for you to immerse your whole body in it. And it has to be water that is running in some way, right? It could be like collected rainwater, but then it is moving right through the mikveh and then out the other side. You can also immerse in a river. You can immerse in an ocean, but you can't create a mikveh out of well water, okay? So what if the 40 sa of water was not all, proper mikveh water, but it got mixed with some other liquid? Then what? If 3 lug of drawn water, right, which is water that's not qualified to be in a mikveh, fell into a ritual bath in which there was less than the 40 sa of water, now then the ritual bath is invalidated, provided that the 3 lug consisted exclusively of water and maintained the appearance of water. But interestingly enough, if a small amount of wine fell into those 3 lug, giving the water the appearance of wine, or if there was less than 3 lug of water and milk was intermingled with the water for the total of the 3 lug, then those mixtures do not invalidate the mikveh. Now we're on page 4a. That discussion took a little while to relate, and then there's yet another one of these. Rav Yehuda in the name of Rav Yehuda in the name of Rav. The Rav Kahana objects. And then Rava resolves. And then this third law, also related to a mikveh, if a barrel filled with drawn water, right, disqualified for a mikveh, fell into the sea. Now, you can immerse in the sea, use the ocean as a mikveh anytime. So this is very odd. But if a barrel full of drawn water, which is no good, okay, fell into the sea, even the Mediterranean Sea, any immersion performed in that place is not valid, as 3 log is not valid, as 3 log of the water from the barrel are assumed to have remained in one place. If the contents of the barrel spilled into a river or any other body of flowing water, immersion there is effective in accordance with the statement of Rav Yehuda in the name of Rav. In other words, if you dumped a barrel of water that's not qualified to be part of a mikveh, drawn water, in the river, and then right where you dumped it, you immersed in that spot, that's a valid immersion because that drawn water will just flow away. Isn't it the same in the Mediterranean, the vast Mediterranean? Yeah, but there are parts of the Mediterranean that are very still, right? Especially on a still day. It could be glassy, right? It could even be glassy when there's no wind. And so if you dumped all that water that's no good and then you immersed in that spot, then your immersion would actually take place within water that is disqualified from being in a mikveh, and therefore your immersion would not count, and you'd have to immerse again in a place where it's a valid mikveh. And then that discussion is finished, and we conclude our discussion of Mishnah number 3. We're now at the bottom of page 4a, where we open Mishnah number 4 here in chapter 1 of tractate Makkos. If witnesses said, "We testify with regard to a man named so-and-so that he is liable to pay another person 200 dinars, and they were found to be conspiring witnesses," they are flogged, and they pay the money that they sought to render him liable to pay. Why do they receive 2 punishments? It is due to the fact that the source that brings them to liability to receive lashes is not the same source that brings them to the liability for payment. This is the statement of Rabbi Meir, minority opinion. And the rabbis say, right, the majority opinion that overruled Rabbi Meir, anyone who pays as punishment for a transgression is not flogged for the same transgression. Likewise, if witnesses said, "We testify with regard to a man named so-and-so that he is liable to receive 40 lashes," and they were discovered to be conspiring witnesses who had lied, so they are flogged with 80 lashes. 1 set of lashes due to the violation of the prohibition, "You shall not bear false witness against your neighbor," and 1 set of lashes due to the verse, "And you shall do to him as he conspired to do to the one they were testifying against," which is the punishment of conspiring witnesses. But this, the 2 sets of lashes for each witness, is the statement of Rabbi Meir, and the rabbis, the majority who overruled him, said no, they are flogged only with 1 set of lashes, 40 lashes, due to the verse, "And you shall do to him as he conspired." Now we're on page 4b. The Gemara on Mishnah 4. With regard to the initial dispute, with regard to the initial dispute between Rabbi Meir and the rabbis in the Mishnah, whether conspiring witnesses pay and are flogged, as Rabbi Meir says, the Gemara asks, well, granted, according to the rabbis, the verse that states, "The judge shall cause him to lie down and to be beaten before him according to the measure of his wickedness," Deuteronomy 25:2. This is what is written concerning one who is liable to receive lashes. And from the phrase, "according to the measure of his wickedness," it is inferred with regard to an individual who commits 1 transgression. For 1 evil doing, you can render him liable. But you cannot render him liable for 2 evil doings, i.e., one cannot receive 2 punishments for the same act. But according to Rabbi Meir, what is the reason that he is punished twice for committing a single transgression? So Ula said Rabbi Meir derived this law from the law concerning one who defames his wife, claiming that when he consummated the marriage, he discovered that she was not a virgin, right? The Torah speaks specifically about this man who marries a woman, right? And he expected her to be a virgin. He was told that she was a virgin. That means that in the ketubah, the ketubah is signed for double the money that it would be than if she was a widow or a divorcee, for example, who would not be a virgin. And then if on his wedding night he discovers that she is not a virgin, that he was lied to, well, then he has a case against her and her father possibly. And, he can raise a stink. And this would be very bad, obviously, for her reputation and the reputation of her family. But if it turned out that the husband was the liar, and for some reason he wanted to get out of marrying her, and he thought that he could tell this lie in order to do that, and then that was discovered, well, then the Torah stipulates, an intense punishment against him. So just as the defamer is both flogged and penalized monetarily. Just as the defamer is flogged and he pays, as it is written, and they shall chastise him and fine him 100 silver coins. Deuteronomy 22, verses 18 and 19. So too, according to Rabbi Meir, anyone who commits a transgression punishable with lashes and a monetary payment is both flogged and he pays. And the Gemara questions this derivation. What is notable about the case of a defamer? It is notable in that... that's what's going on. What is notable... Wait a minute, where am I? What is notable about the case of a defamer? It is notable in that the payment of the defamer is a fine. A fine is different than monetary restitution. Right? A fine is a fixed amount that the Torah stipulates shall be paid in certain kinds of situations. That's different than damages. A fine is not the same as damages. Right? Ask anyone, you've seen it, right? Under secular law also. These are different things, right? If you damage somebody, they're going to measure what their damages are. Sometimes the law will also say, in addition to the damages, you owe a fine of. Maybe you owe the fine to the person you hurt. Maybe you owe damages to the person you hurt and a fine to the government, right? These are different values. So how can the law of conspiring witnesses whose payment is not a fine, but rather monetary restitution of what the harm they would have caused to the one if their testimony had been believed, so how can we derive their punishment, which is based on monetary restitution, from a law that speaks about fines? So the Gemara answers that Rabbi Meir holds in accordance with the opinion of Rabbi Akiva, who says the payment that conspiring witnesses are liable to pay is a fine. It's measured according to what they would have made this other person pay, but the fact that we make them pay what they would have obligated him to pay with their lies is itself a fine. Now the Gemara comments, there are those who teach this statement of Ula with regard to that which is taught in a Baraisa. It is stated with regard to the Paschal offering, right? When the temple is standing and we would bring the Pesach, either a sheep or a goat, as a sacrifice in Jerusalem on Passover. We would sprinkle its blood on the altar, right? And then we would eat it that night, and then after that night was over, the rest needed to be consumed, right? We've talked about the laws of the Paschal offering. So what about that? It's stated with regard to the Paschal offering, and you shall let nothing of it remain until morning, but that which remains of it until morning, you shall burn with fire. That's Exodus 12:10. So the verse comes to provide a positive mitzvah to burn the remains after it has taught a prohibition, right? It says, you shall not leave any of it until morning, right? You should eat all of it. And that's why you register a group, right? And usually there's many more people than the food of the Paschal offering. That's why they would also bring a peace offering so that there would be enough food for them to eat. the law that all of it had to be eaten by the morning is just on the Paschal offering. Plus, they could have other food as well. But if they did leave some of it over, that needed to be burned up. So you have both a negative mitzvah, a prohibition, don't leave any of it until morning. But if you did leave some of it till morning, then you have the positive mitzvah of burning that, to get rid of it so that you don't eat it accidentally. So what is the point of this? The verse comes to provide a positive mitzvah to burn the remains after it has taught a prohibition which states you shall let none of it remain. To tell you that one is not flogged for its violation. This is the statement of Rabbi Yehuda. This is a prohibition whose transgression entails the fulfillment of a positive mitzvah in which the mitzvah serves to rectify the violation of the prohibition. And since the mitzvah is the rectification of the violation of the negative prohibition, you don't apply lashes as the correction for violation of the negative prohibition. So Rabbi Akiva says, the fact that one is not flogged is not for that reason. Rather, it is due to the fact that this prohibition, and you shall let none of it remain, this is a prohibition that does not involve an action, as one violates the prohibition through failure to take an action. And concerning any prohibition, and concerning any prohibition that does not involve an action, one is not flogged for its violation. And the Gemara learns by inference that Rabbi Yehuda holds in principle with regard to a prohibition that does not involve an action, that one is flogged for its... I just want to read that again. Rabbi Akiva is saying it's not that the reason flogging doesn't apply is because there was a negative prohibition rectified by a positive commandment, but rather because when the negative prohibition was violated, it was done not through an action, but rather inaction or a lack of action. And sometimes speaking is the violation, but speaking is not considered a physical action, right? And so that's why flogging doesn't apply. And so the Gemara learns by inference, that's what Rabbi Akiva said. Therefore, what Rabbi Yehuda holds in principle with regard to a prohibition that does not involve an action is that one is flogged for its violation. Now, from where does Rabbi Yehuda derive that one is flogged for violating a negative commandment, even if that violation comes as a result of no action? So Ula said Rabbi Yehuda derived this law from the defamer. Just as the defamer violates a prohibition that does not involve an action, as it involves only speech, and one is flogged for its violation, so too with regard to other prohibitions that do not involve an action, one is flogged for their violation. And the Gemara questions this derivation. What is notable about the case of the defamer? It is notable that he is flogged and he pays for a violation of a single prohibition due to the stringency. That's a very stringent law, unusual. Other less stringent prohibitions cannot be derived from the case of the defamer. Therefore, Reish Lakish says that Rabbi Yehuda derives this principle from the case of conspiring witnesses. Just as the conspiring witnesses violate a prohibition that does not involve an action, and an individual is flogged for its violation, because they told a lie, right? They didn't do an actual action, they just spoke when they lied. So too, with regard to any prohibition that does not involve an action, one is flogged for its violation. But the Gemara challenges this also. What is notable about the case of conspiring witnesses? It is notable in that the witnesses do not require forewarning in order to administer their punishment, which is an exception to the principle that corporal punishment may be administered only after forewarning. Due to that stringency, other less stringent prohibitions cannot be derived from the case of conspiring witnesses. So the Gemara answers, the case of the defamer will prove that the absence of forewarning is not a significant factor, as the defamer requires forewarning and nevertheless is flogged for a prohibition that does not involve an action. And the inference has reverted to its starting point. The defining characteristic of this case is not like the defining characteristic of that case, and the defining characteristic of that case is not like the defining characteristic of this case. What do we look at? Their common denominator. And their common denominator is that in both cases, there is a prohibition that does not involve an action, and one is nevertheless flogged for its violation. And so too, according to Rabbi Yehuda, with regard to any prohibition that does not involve an action, one is flogged for its violation. as opposed to Rabbi Akiva, who says we flog people for violating negative prohibitions if they perform an action, right? Like you shall do no work on Shabbos, and a person does work on Shabbos, that would be a flogging offense. But somebody, who neglects to do something, like you shall not leave any of it over until the morning, and they just don't eat it all, right? And they let it be there in the morning, Rabbi Akiva would say that is a flogging offense. I say that is not a flogging offense. Rabbi Yehuda would say it is. So the Gemara questions this derivation. What is notable about their common denominator? They are notable in that payment in both cases is a fine, and therefore other less stringent prohibitions cannot be derived from them. And the Gemara answers, this is not difficult. Rabbi Yehuda does not hold in accordance with the opinion of Rabbi Akiva that the payment of conspiring witnesses is a fine. In his opinion, therefore, that is not a common denominator. Rather, the Gemara proposes an alternative refutation. What is notable about their common denominator? They are notable in that the cases of the defamer and of conspiring witnesses both contain a stringency. Therefore, other less stringent prohibitions cannot be derived from them. And the stringency in the case of the defamer is that he is both flogged and he pays. And the stringency in the case of conspiring witnesses is that they do not require forewarning. So the Gemara answers, and Rabbi Yehuda does not refute a derivation from a common denominator based on the fact that both cases contain a different stringency. He holds that the mere fact that there is a stringency in each does not serve as the common denominator. I'm almost done. Questions or comments, please get them in now. The Gemara resumes its analysis of the dispute between Rabbi Meir and the rabbis in the case of conspiring witnesses who testify that another person is liable to receive lashes. Right? They come and say, oh, this person was already tried and sentenced to lashes, but he ran away. And now in this new town, they come and say, oh, yeah, this guy is liable to receive lashes. But that's a lie. They conspired in their testimony, so therefore they are going to receive the lashes that they would have obligated this other person in if their lie had been believed. In this case, Rabbi Meir holds that they would receive double lashes. Right? The standard sentence is 40, they would receive 80. One set of lashes due to violation of the prohibition, you shall not bear false witness against your neighbor, and one set of lashes due to the verse, and you shall do to him as he conspired to do to the other. And the rabbis say they are flogged only with 40 lashes due to the verse, and you shall do to him as he conspired, but we don't then apply the other set. And the Gemara asks, okay, with regard to the rabbis, concerning this verse, you shall not bear false witness against your neighbor, what do they derive from it if one is not flogged for its violation? Right? This person, these witnesses, they violated 2 Torah prohibitions. Conspiring witnesses, therefore they're punished to what they would have imposed on the one that they conspired against, and do not bear false witness. So those are 2 different prohibitions that they violated, but they violated them with the same action, which was telling the lie of the false testimony. So the Rabbi Meir would impose 2 sets of lashes because they violated 2 prohibitions. And the rabbis say, no, it was only one action, telling the lie, and that's why they only get the 1 set of lashes for they conspired to do. But here's the question, right? So the rabbis concerning this verse, you shall not bear false witness against your neighbor, what do they derive from it? So the Gemara answers, they require that verse as a prohibition against conspiring witnesses. What does that mean? Every punishment enumerated in the Torah, including that of conspiring witnesses, is accompanied by an explicit verse prohibiting that action that results in the punishment, right? So the Torah will say, it is prohibited to do such and such, and separately will say, and if you do such and such, the punishment is. So there's never going to be something in the Torah that says that if you do such and such, the punishment is, without somewhere else another provision saying it is prohibited to do such and such. So what the rabbis are saying is, the punishment for conspiring witnesses is such and such. Where is the prohibition on conspiring? This, you shall not bear false witness. They require that verse as the prohibition against conspiring witnesses. So then the Gemara asks, well, with regard to Rabbi Meir, who holds that conspiring witnesses are flogged for violating this prohibition, from where does he derive a prohibition against conspiring as witnesses? So Rabbi Yirmiyah says Rabbi Meir derives it from the verse written in the context of conspiring witnesses, and those who remain shall hear and fear, and shall not continue to perform any more evil of this kind in your midst, the deterrent effect. So the verse warns that conspiring witnesses should not continue with their sinful conduct. So the Gemara asks, okay, well then according to the rabbis, why don't they derive the prohibition against conspiring witnesses from the same verse that Rabbi Meir used? What do they do with that? So the Gemara answers that verse is necessary according to the rabbis for the requirement of proclamation. When the witnesses are taken to their execution, if they conspired against somebody in a death penalty case, and if their testimony was believed, the defendant would receive the death penalty, then the conspiring witnesses receive the death penalty when they're revealed to be liars in a capital case. And in that situation, as they're being walked out to their execution, we need to proclaim why they're being executed. Namely, they conspired and provided false testimony in a capital case, and now they are being executed for that. That's proclamation. When the witnesses are taken to their execution, there is a mitzvah for the court to publicly proclaim the transgression for which they are being punished in order to deter others from committing the same transgression. And Rabbi Meir derives the requirement of proclamation from the phrase in that verse, shall hear and fear. The prohibition is derived from the phrase, and shall not continue to perform any more evil. And that concludes our discussion of Mishnah number 4. With God's help, we'll pick it up tomorrow at the regular time, 6 p.m. Pacific, with Mishnah number 5 here in chapter 1 of tractate Makkos. Just a couple of comments. Joseph, it makes sense that we can't deny the justice of Torah, but we may deny the personal benefits afforded by the law, depending on which, without ending up in heresy, right? It makes sense. You can't say that the law doesn't exist or doesn't apply generally. You could just say, I waive the protection that this law affords to me. Sharon, my head is spinning with the convolution of these terms. I must reread. This is definitely one of those difficult passages. I'm with you. And John Bonis says, loving your subject. Loving your subject is one of the best qualifications for being a teacher. Absolutely. Absolutely. And sometimes it's hard, right, when it gets really technically difficult to keep saying, I love this. I really love this, but I can't understand it. And really, the sages express such wonderful, wonderful love of Torah, right? We're just trying to understand and give over, right, to teach what they derived over years, decades, centuries, figuring all this out. Such a wonderful act of passion that we benefit from today. That's what I've got for us today. And with God's help, see you tomorrow, Wednesday at the regular time, 6 p.m. Pacific. All the best. We don't blow out candles. That's